back to winning isn't easy. Let's talk about protecting your ERISA disability benefits while you're incarcerated. Now, being incarcerated doesn't automatically terminate your benefits, but it introduces really significant complications. So, what do you need to understand to protect your benefits? Number one, you need to understand your burden of proof. You are generally required under the terms of the disability policy to get appropriate medical treatment based on the nature of your medical condition and to provide ongoing documentation to confirm your disability. We have to go back to the policy. We're looking for those two terms, but we also want to understand how the policy or plan defines the definition of disability. Is it the inability to do your regular occupation? Is it your inability to do any occupation? And of course, we need to understand what that definition is and the nature of the proof that we need to submit. Number two, we've got to document all of the medical care. And then I think that's important before incarceration, during incarceration, and after incarceration. While you're incarcerated, I will tell you that medical treatment is going to be limited, but you should be keeping a record of your interactions with the prison medical staff, including your medication logs, whether you got any physical therapy, the nature of the treatment that you got, whether you were injured or assaulted, if you will, while you're in prison. Now, if you've had prior care outside prison, obviously you want to maintain copies of that because courts are going to look at the medical records before you were incarcerated, the medical records while you were incarcerated, and then, of course, after you are released, the nature of the medical care that you have gotten. And so courts are going to often look at the totality of the treatment history rather than the isolated period. Number three, you have to communicate with your insurer. That is going to can be difficult, and I'm going to explain in a story what we did about not necessarily communicating while my client was in jail. But generally, they're going to find out that you are incarcerated. And I prefer, if possible, to actually get, prior to the incarceration, updated medical records and evaluations. Normally, carriers want to see documentation generally at least once a year, so we can at least buy ourselves a year, if you will. But ultimately, you're going to have to provide them with medical updates. And generally, that can be, difficult if you are getting treatment from prison doctors, because they're not going to let you go out and get your own evaluation or see your own doctor so you can maintain your insurance coverage. But depending on the nature of your medical condition, you might ask for a temporary suspension of the request for documentation. So, for example, in a case where the person is getting treatment, undergone surgery, and is a bit, quiescent, if you will, in the treatment, because there's no improvement expected, you might want to say to the carrier, I've been submitting my attending physician statement forms. Here's a current exam. Can we extend the period of time in which for me to submit the medical documentation to a year? But you want to play that one depending on the nature of your disability, the nature of the carrier. Again, before you are incarcerated, then after you are released, you want to make sure you are seeing treating physicians and specialists, because I will tell you that courts will generally give greater weight in these types of cases to a physician's opinion who has seen you before incarceration and after incarceration. So you want to try to maintain contact with your outside physicians or specialists and potentially have a video or Zoom, if you will, evaluation, of course, subject to the agreement and approval and permission of the particular facility, correctional facility that you're in. You also might want to be sending notes to your doctor about the ongoing problems that you have. So let's say you have migraines. You might want to continue to keep a migraine diary and send that to the doctor. Now, once you're released from the prison, you want to timely file an appeal if your benefits are terminated. And that should include all of the applicable prison medical records, documentation of your pre-incarceration medical treatment, any logs or records that you kept about the nature of your symptoms while you're in prison, and I encourage that. And then, of course, documentation of your post-incarceration medical treatment, preferably from the physicians who treated you originally. And again, you've got to understand these policy-specific provisions, because some plans will explicitly allow for a temporary suspension of benefits if you can't provide the required documentation for reasons beyond your control, like incarceration. So you've got to really familiarize yourself with the policy language and especially the clauses relating to ongoing proof of disability, medical examinations, and benefit suspension. Let's also talk about functional limitations versus legal requirements. Courts will often distinguish between factual disability and procedural requirements. So being unable to attend regular appointments or submit records doesn't necessarily eliminate a factual disability. And I spoke about that in an earlier episode in this particular podcast. The judges may consider pre-incarceration disability and prior treatment history, available records during the incarceration, and then again, the post-discharge medical records. And I will tell you that legal assistance is really critical in these cases. The ERISA disability law is complex, and cases often involving incarceration will hinge on nuanced interpretations of policy definitions, evidence requirements, and the interpretation or interaction between factual and procedural disability. So if we've got to file an appeal, we want to make sure that there's robust medical documentation that is going to explain both factually, medically, and legally the nature of your disability and the fact that it shouldn't be negated by temporary inability to provide documentation. It's really crucial that, again, consistent with the terms of the policy of the plan, that you are maintaining continuity in terms of the medical treatment. I've seen courts award back benefits for periods of wrongful termination, even when the person is in prison, but then deny the post-discharge release period because the person didn't get medical treatment. So let me tell you the story of a pilot that I represented. Unfortunately, he was driving while intoxicated, resulting in the deaths of several individuals. Obviously, he lost his pilot's license, but he had a disability policy, and he knew he was going to be incarcerated. So what we did in this case was to have him examined by his treating physician for his medical condition just prior to incarceration. Number two, we continued to submit documentation of his medical treatment that he received in prison, and we had gotten them to agree to an extension of that particular time in which to submit his medical documentation based on the nature of his condition. But we also had him keep logs and records of the prescriptions that he was getting, the treatment he was getting, his response to the treatment, and his ongoing symptomatology. Upon his discharge, we submitted all that information, and his benefits were paid. So it was meticulous planning, strategy, record keeping, proactive communication, comprehensive documentation from his treating physician, and our guidance that helped preserve his rights and maximize the likelihood of his continuing benefits, which in fact continued. So thank you today for tuning into this episode of Winning Isn't Easy. If you found the episode helpful, take a moment to like our page, leave a review, share it with your family and friends, and subscribe to this podcast so you get notification when the next episode drops. Please join us next week for another insightful discussion of Winning Isn't Easy. Thanks for listening.